The Supreme Court shall now examine whether a state can establish a Second Amendment Preservation Act with the intention of transforming a state into a Second Amendment sanctuary. In this video, we're going to be discussing a very important Second Amendment protection lawsuit, which is once again appearing before the Supreme Court. This is a dispute dealing with a state's Second Amendment Preservation Act. We've explored this case previously because recently the Supreme Court delivered an order rejecting a state which would have safeguarded Missouri's Second Amendment Preservation Act. Following the rejection of that order, this lawsuit was subsequently returned down to the Eighth Circuit, who recently released their verdict in this matter. The Eighth Circuit aligned with the then Biden administration and concluded that the Missouri SAPA legislation was invalid in its entirety. But now Missouri has submitted their formal petition to the Supreme Court, and the Supreme Court will soon deliberate in just 2 weeks whether they will accept review of this case and whether or not they're going to analyze Second Amendment sanctuary concerns. For those unfamiliar, back in 2021, Missouri enacted a law called the Second Amendment Preservation Act. The statute established the state's interpretation of the Second Amendment and imposed limitations on the assistance and resources that the state would offer to federal bodies and representatives in their attempts to implement federal regulations, which, in Missouri's perspective, violated the Second Amendment. The statute prohibits Missouri's officers, agents, and government personnel from assisting federal agents who are attempting to enforce those inconsistent regulations. The law also generated a civil remedy where anyone can pursue Missouri officials if they assisted to implement a federal regulation that infringed the Second Amendment. The Missouri statute is comparable in nature to the Texas abortion legislation SB 8 and the recent Supreme Court decision in the whole women's health dispute. With the Texas and Missouri statutes and how they're constructed, you can't obtain an umbrella injunction against the state or the Attorney General since they're not actually the individuals enforcing those laws. Rather, you would need to secure a preliminary injunction or an injunction against every private citizen who files these civil lawsuits. In this Missouri dispute, the District Court on Evaluation ruled in favor of the Biden administration, invalidating the Missouri Preservation Act in its entirety. Now, in reaction, the state of Missouri then appealed up to the Eighth Circuit. Missouri requested for the Eighth Circuit to suspend the lower court's ruling while the appeal was proceeding. However, the Eighth Circuit denied that suspension and ruled in favor of the Biden administration. And that prompted Missouri for the first time to approach the Supreme Court on an emergency basis. They filed an emergency application and they desired the Supreme Court to grant that suspension. However, on evaluation, the Supreme Court issued an 8-1 order rejecting that suspension request by the state of Missouri. Only Justice Thomas was in support of granting the suspension in favor of the state. Now, after the Supreme Court's denial directive in this case, it was then sent back down to the Eighth Circuit, who then conducted expedited arguments and hearings in this matter. Eventually, the Eighth Circuit ruled in favor of the federal government once again, the Biden administration, invalidating the SAPA law in its totality. But now Missouri has filed their cert petition to the Supreme Court, asking for the official review of this lawsuit on the final merits. In the petition, Missouri presents 3 primary questions for the Supreme Court to address in this matter. First, can the federal courts scrutinize a state's reason for exercising 10th Amendment authority? Second, does the Constitution forbid states from exercising 10th Amendment authority when motivated by a worry that a federal statute is unconstitutional? And third, is the state official a proper defendant under Ex parte Young simply because the official is governed by a statute? And does the official also need to possess power to enforce the law? Missouri continues to argue in the petition that before this lawsuit, it seems no federal court had ever blocked a state from exercising 10th Amendment authority simply because of the rationale the state expressed for exercising that authority. The Eighth Circuit did that here, invalidating a state law solely because the act indicated that the legislature believes certain federal statutes are unconstitutional. The Eighth Circuit's determination creates multiple circuit splits and is as incorrect as it is unprecedented. It proclaimed a Missouri law unconstitutional solely because of the law's legislative findings, specifically the legislature's viewpoint that some federal statutes are unconstitutional under the Second Amendment. The court took no issue with what the Missouri law accomplishes, only with the legislative findings in what they express. Indeed, the court acknowledged that a law with the same effect but different findings would be acceptable. As the court phrased it, Missouri may lawfully withhold its assistance from federal law enforcement if it selects a different reason, such as withholding resources as a matter of policy rather than as a matter of constitutional interpretation. One of the aspects that Missouri is highlighting here in their petition is that the Eighth Circuit essentially stated the framework and potential operation of this law is valid, but they ultimately struck it down because of its underlying Second Amendment objectives. Missouri contends that the Eighth Circuit went against clear precedent and found that the state officials could be sued because the court believed that the state played a role in enforcement simply by adhering to the state law. Essentially, the Eighth Circuit discovered that compliance and non-action was actual enforcement, and therefore the state and the Attorney General could be sued in this challenge. Now, this legislation was originally contested by the Biden administration, but now the Trump administration is in charge of the government, obviously, and now they possess the control of this case and what stance they actually want to adopt in this challenge. Originally, the federal government, here the Trump administration, was scheduled to file the reply brief to the Supreme Court on February 26th, but they obtained an extension. The Trump administration has now received multiple extensions in this case to determine essentially what they want to do and what Second Amendment position do they want to assume in this lawsuit. The Trump administration's response to this petition is now due on May 27th. So the administration will have to choose in just a couple weeks how they want to approach this challenge. One of the crucial aspects and kind of complication in this case is that the petition was submitted by the state of Missouri. So unlike prior Supreme Court petitions that were filed by the administration, they essentially don't have the option to just abandon the case. So it's not like the Trump administration can just declare, "We're not going to challenge this," or "We're going to withdraw the petition," because they're not the ones that actually filed it. Instead, they will have to respond to the petition in some fashion. I have no uncertainty that the 2A task force is taking a thorough look at this case and trying to devise a pro-2A approach. Maybe there's some method where they can say, "Hey, we're not going to challenge this, that we concur that we shouldn't have brought this lawsuit. And yes, to the state of Missouri, you can have a SAPA law in effect." How they accomplish that, we're not certain yet. But this is one of those very fascinating things, especially because the current U.S. Solicitor General was previously the attorney in Missouri who represented the state and Missouri's interest to protect the SAPA law. And so the current U.S. Solicitor General was responsible for this at the lower court levels, defending the Missouri SAPA law. He was battling against the Biden administration when the Biden administration was trying to override the SAPA law. So there's a lot happening here where you have former attorneys for Missouri in this specific case who are now at a higher position and essentially the U.S. Solicitor General. At this juncture, the Supreme Court has given the Trump administration multiple extensions, kind of based on the identical reason. So at some point, the bill will come due and the United States government will have to respond to this petition. However, my general impression from the Supreme Court may be that they don't want to accept any high-profile Second Amendment cases. And maybe they're going to let the Trump administration continue to postpone this case down the road. Currently, we're still waiting to observe how the Supreme Court wants to handle other high-profile cases like the Snope rifle ban case and the Ocean State tactical magazine ban case that have been relisted multiple times, relisted again this week. And we're still waiting to see what Supreme Court wants to do in those disputes. And even in those challenges, the clock is currently ticking because they need to grant review. And if they don't grant review before this term, it's going to be delayed to next term. I suspect that perhaps something's going to occur maybe at the conclusion of this term where you have the cleanup conferences, and hopefully it doesn't reach that point. But even at the cleanup conferences, there is a group of orders that can be issued after those conferences. And the expectation would be that Supreme Court would grant review to those cases. And then essentially those cases would progress during the Supreme Court's next term. So they could kind of execute a fast one at the last moment, grant review to those two cases, and then go on their summer recess and let all the anti-gunners worry that the Supreme Court is taking a rifle magazine ban case. So a lot is transpiring right now at the Supreme Court level, and a lot is happening with the Second Amendment issues at large. We have numerous challenges going on right now, not just in multiple federal courts, state courts, cases pending in front of the Supreme Court. We have the executive taking many actions in regards to the Second Amendment with the new task force. And then we have a ton of battles occurring right now in front of Congress with the SBR and the suppressor issues. So a lot is shifting right now. And this is one of those critical cases that is pending in front of the Supreme Court. But perhaps the Trump administration is just trying to delay the can down the road because they don't know how they want to manage this. They're kind of in a difficult position. Maybe they don't want to say states could just implement these types of SAPA laws. And maybe they're just going to try to delay this can down the road as much as feasible if the Supreme Court would permit them. So again, presently, Trump administration is set to respond to this petition in just 2 weeks, and we're going to see how this evolves. And as things change, I will inform you guys know. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And never forget, this nation was constructed by farm scholars, and this nation will be preserved by scholars.